Good morning. Calling the matter of CP2024-28, Agostini Insurance Brokerage Limited against Trinidad and Tobago Civil Aviation Authority and Gabriel Insurance Brokers Trinidad and Tobago Limited interested party.
Good morning, everyone. Welcome to today's proceedings. Can the parties confirm that they are hearing me clearly?
Good morning, Mr. Chair. Confirming.
Thank you all. Let us the panel, we are going to reintroduce ourselves. So I am David Shallery, presiding as your panel chair today. And with me today are Mr. Jason Edwards and Ms. Joy Joseph Lara. As some housekeeping, is the applicant or representative of the applicant present?
Mr. Chair, Shari Fitzpatrick, appearing on behalf of the applicant, and Ms. Malika Sandley is the representative of the applicant this morning.
Thank you. Noted. Is the respondent or a representative for the respondent present?
Yes, good morning, Chair. This is Carrie Price, Accounting Officer, Trinidad and Tobago Civil Aviation Authority. I have to beg your indulgence. There's an internet issue at the compound, and Dr. Rose and the other attorney are not able to log on as yet.
Okay. Thank you, Mr. Price. We would note when they're able to come in the room. I am also seeing Ms. Rose. So we're noting that Ms. Rose is present here on behalf of the respondent. Ms. Rose, would you be able to zoom in? Chairman. Would you be able to zoom in your device so we can see you? I would note that you can't use the raise hands device, so it will be helpful if I can see you closer. So in the event that you need to raise your hands, I could recognize it quickly.
I'm seeking assistance from the technical team to do that. I apologize. I entered appearances thinking that I was not on mute, okay. And Mr. Price didn't hear me, but we are here. If it please, Dana, if we can get the technical team to zoom us in.
Sure.
More, please. Mr. Chairman.
Yes, Ms. Rose.
But Mr. Chairman, if it pleased you, good morning. Putting on record, I am Margaret Rose. I appear with Ms. Dana Marie Smith, who is here with me in the room. Mr. Price is also here present, the accounting officer representing the respondent, but not in the room with me.
Okay. Thank you, Ms. Rose. Duly noted. We would continue with the ground rules, and in the meantime, you can ask your technical team to assist you, but I would continue with the ground rules in the meantime. So just a reminder of the ground rules which we would have gone through last Friday.
Mr. Chair, sorry. Mr. Chair, sorry, yes, just for the record.
Oh, yes.
Sorry, Mr. Chair. Should it please the Honourable Panel, I am Kimberly Senath. With me is Ms. Christina Bermudez-Lucky. On behalf of the interested party for these proceedings, please, Honourable Panel, Gallagher Insurance Brokers, Trinidad and Tobago Limited. And apologies for interrupting you mid-ground rules.
That's okay, Ms. Senath. We have duly noted your presence today, as well as the interested party. So let's get into the ground rules. Ensure that your microphones are muted when you are not addressing the panel. Remember to unmute your microphone when it is your turn to speak and speak directly into the microphone. We're in a room with multiple devices. Ensure that all other microphones are muted except for the relevant one being used to contribute today. Avoid interrupting a speaker. Let a speaker finish before you attempt to do so, and you may use the raise hand feature on Teams, or you may physically raise your hands if you intend to make an objection or you want to interrupt a speaker. Ensure that you are clearly visible by maintaining a reasonable distance from the camera so that we can see your head and upper body. And it must also be remembered that witnesses must not be able to hear the evidence of other witnesses. and therefore would not have access to the open link until the time has arisen for them, for their evidence to be heard. Parties and witnesses will be required to show the panel around the room in which they are sitting to give evidence by turning their video device around the room, and they will not be allowed to receive assistance by way of documents, persons, and or any other prompts without the permission of the panel. Unauthorized recording of the proceedings is not allowed. Parties to the proceedings can request an access to the records of the proceeding by filing the prescribed Form 16 to the office. In the event that connection is lost or we are interrupted in any way during the hearing by electronic means, the representative and or parties must immediately notify the hearing secretary by calling 226-2477 extension 1161. I would repeat that, 226-2477 extension 1161. And this must also be confirmed as soon as practicable by email to challenge@opr.org.tp with the case reference number in the subject line and copy to all other parties in the matter. Participants are also advised that these proceedings are not intended to be adversarial, so I implore you that we maintain decorum and be courteous to each other during the conduct of these proceedings. Where we ended off last Friday would have been the presentation of the first witness by the applicant, and we would be commencing today with the witnesses for the respondent. But before we do, there's a matter that we would like to address, in that we had received a Form 15, which is an application for costs, which was filed by the applicant last week. Representative of the respondent, did you receive the Form 15?
Yes, please, Milan. Yes, please.
Thank you, Ms. Rose. Noted. So the Form 15 has been filed and has been received by the respondent. Let the record so show. Respondent, can you please confirm that your witnesses are present and are able to give evidence and to be cross-examined?
Yes, please, Mr. Chairman, all witnesses present. We're just trying to set up the room so that there's a space for the witness to sit that is not too close to me. But we're ready. Yes.
Thank you, Ms. Rose. Would your witnesses be appearing in the same order that they would have been filed? I have Mr. Pearson first. Before you answer, Ms. Rose?
No, Mr. Chairman. Are all witnesses required for cross-examination? First of all, because if all are not required, we would just be tendering and relying on the witness statements. And if they are all required to give evidence, we would want to start with Ronda Sooklalsingh so that we can address some of the substantive issues first.
Ms. Rose, yes, all witnesses should be available for cross-examination. I see the hand of Ms. Sina to raise. Ms. Sina?
Thank you, Mr. Chair. Before we proceed, the interested party will be making an application this morning, please. And on the basis of having regard to how the evidence went on Friday of the applicant's witness in the form of Mr. Brent Mitchell, out of an abundance of caution and in keeping with the overriding objective of the rules of the hearing panel, we would be reserving our right and we would like to tender evidence from one of our witnesses, please, Mr. Chair. The name of the witness would be Mr. Jesse Can, please.
In light of that new information, Ms. Sinat, please permit me a couple of seconds to confer with the panel.
Thank you, Mr.
It
Chair.
did not have been filed prior, so it is something that we need to discuss.
Thank you, Mr. Chair.
Ms. Sinat,
Yes, please, Mr.
Would-
Chair.
would you narrow down the issues that the witness that you have just introduced would be presenting, please?
Yes, please. So before we begin there, the interested party would be relying on Rule 8.4 as it relates to our duty to disclose. Which requires any party to provide documents as the hearing panel considers necessary for a full and satisfactory understanding of the subject of the proceedings. Mr. Chair, without going into the substantive evidence which we intend to bring before the honorable panel, it will consist of evidence as it relates to a timeline. So,
Yes.
in accordance with a chronology of events from when the tender process was opened, throughout the course of events up and until a letter of award was granted, please, Mr. Chair. And my witness will be seeking to provide an explanation in terms of what transpired between this narrow time frame, please, my lord. It is just a mere matter of weeks, so I do not anticipate. I know we had allocated a certain period of time for this matter to be completed by today. I do not anticipate that this witness is going to be very long, please, my lord. Of
Thank
course,
you,
that
Ms. Tina.
depends on my colleague, Ms. Fitzpatrick, but I do not anticipate it to be very long.
Okay. Ms. Fitzpatrick, first of all, just before we took the brief break to confer, I saw your hands up. Is there something you'd like to raise before I continue?
Yes, please, Mr. Chair. I just would like to be heard before you deliberate on this issue. What I would like to say is that this is coming at a very late stage when the interested party made its application to join the proceedings on the 3rd of October. That was over 10 days ago. In that application, please, Mr. Chair, they in fact identified that they were going to file witness statements and call the evidence of the same Mr. Jesse Can. So that it cannot be right that after having heard not only seen the submission of, because I did serve on my friend this weekend, the submissions of the applicant, and having heard the evidence that only now there is some evidence to be given. Of course, I accept that the duty of disclosure applies to the interested party and that anything that's relevant ought to be disclosed, but that does not allow the interested party at this stage to file a witness statement to rely on that. And simply it is just unfair for the applicant at the hearing, and in fact at the second day of the hearing, to have to deal with this evidence. It is really being sprung on us. So on that basis, we are objecting, please, to any evidence of the interested party being admitted.
Thank you, Ms. Fitzpatrick. Representatives of the respondent, may I have your comments on the request, please?
Yes, thank you for giving me the opportunity to respond here. I would like to refer to the panel to Rule 8.1 of your hearing rules and procedures, which explicitly sets out that the duty of disclosure until the conclusion of the challenge proceedings, so that there is clearly a contemplation in these proceedings that as the matter progresses, as issues arise, there is a continuing duty on every party before the hearing panel to make disclosure. Then at Rule 8.4, contrary to what my learned friend has submitted, that it cannot be that at this late stage, this application can be made, 8.4 explicitly sets out at any stage in the challenge proceedings, the hearing panel may order that a party disclose to the panel or to another party. So I would, once the panel considers that it is necessary for full and satisfactory understanding of the subject of the proceedings, and in my respectful view, Mr. Chairman, the role of the interested party here in what was done post the communication of them being successful is very relevant to the implications of any order of this panel in respect of these procurement proceedings. So I would support and join in the application of the interested party pursuant to 8.4. I have no objection to that and to what my learned friend is requesting.
Mr. Patrick, I see your hands.
Yes, Mr. Chair, I just want to clarify for the record that I am not disagreeing with the fact that disclosure is or the continuing obligation of disclosure exists. What I'm saying is my friend is entitled and in fact ought to disclose anything that is relevant. And I would simply ask why it was not disclosed at an earlier stage. but it does not mean that evidence can be adduced in the form of the witness's testimony. And I don't know, I see no reason why, if there are documents that need to be emailed to the panel for what it's worth, but the witness statement is, or the oral evidence is the issue that I have. And I will refer you also, please, panel, to Rule 9.8, which says that a party who fails to provide a witness statement or witness summary in accordance with this part may not call the person as a witness without leave of the hearing panel, which may be granted on such conditions that the hearing panel considers just. And with respect to what is just, I again say that this is coming at a time when the interested party has now heard the submissions and the evidence of the applicant, and that can't be what is contemplated, that you can now bring evidence almost in response to what has been raised, when you clearly understood that you were entitled to file witness statements, having on October 3rd said that Mr. Khan was coming to give evidence, and you opted not to bring him as a witness, so that the applicant has not had time to consider his witness statement. I have not had time to consider his evidence, and to essentially determine what do I need to cross-examine this witness on.
Thank you, Mr. Fitzpatrick. The panel will take a short break to confer, and we will return with our decision.
Grateful.
The panel is now ready to give its decision on the matter that was just raised. Given Given that a witness has already presented, the panel is of the view that bringing in the witness your witness at this time, Ms. Sinat, would be prejudicial to the proceedings. However, you do have the opportunity to file documents, not a witness statement, but documents relative to the matter that you wanted to bring up. We would also like to know if if the documents or information was in the possession of the interested party, at least give us a reason why at this late stage it is now being brought up. So that would be the decision of the panel on that matter.
I'm guided, Mr. Chair. Thank you.
You're welcome, Ms. Sinat. So we would continue with the proceedings. The respondent would have noted that they are bringing in their first witness would be Ms. Ronda Sooklalsingh. Ms. Ronda Sooklalsingh.
Yes, please, Mr. Chair.
Does the representative of the respondent wish to give an opening statement?
No, please, Mr. Chairman. We will rely on our written submissions that we filed at the beginning of this matter.
Thank you. Noted.
Good morning.
Is your witness ready?
Yes, please. Witness is tendered for cross-examination.
Hold please, Miss. Hold please. Miss Sooklalsingh will need to undergo her affirmation. So the hearing secretary would now conduct that part of the proceedings, and then we will continue.
Sooklalsingh.
Yes, hello.
Good morning. Can you please repeat after me?
Yes.
I, please state your name,
Ronda Sooklalsingh,
do solemnly, sincerely, and truly affirm
do solemnly, sincerely, and truly affirm
that the evidence I shall give to the hearing panel in this case
that the evidence that I shall give to this panel in this case
shall be the truth.
In this case, shall be the truth.
The whole truth.
Shall be the whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you. Should I mute her?
Ms.
Good
Rose,
morning.
before we
I apologize.
Ms. Rose, before we continue, please know that we are accepting the witness statement that was submitted on the 8th as standard. However, we're suggesting examination in chief of the additional documents that would have been submitted on Friday and appended to the witness statement.
Yes, please, Mr. Chair. Mr. Chair, I would ask that the technical team put up on the screen the certificate of insurance, reference number 2024 AERO TTCA/0001, dated 1st of October 2024. that is being, so I will ask some preliminary questions of the witness. Ms. Sooklalsingh, for the purposes of the record, can you state what your position is?
Cost and budget analyst.
And in that position, you would be privy to the negotiations and the securing of policies for the Trinidad and Tobago Civil Aviation Authority?
Yes.
And are you aware as to whether or not an aviation policy was entered into for the period October 1st, 2024 to the 30th of September 2025?
Yes, we do have an aviation liability policy in place for that period.
And you would be in a position to recognize that document if shown to you?
Yes.
Mr. Chair, if the document can be put up on the screen for the witness to verify, and may I please inform the hearing panel that Mr. Price has just entered the room. Mr. Carey, Price, the
Thank you, Ms. Rose. We note the presence of Mr. Price in the room. Getting the documents to be shown on the screen shortly. The document is now on the screen.
Mr. Chair, Mr. Price has just informed me that another representative of the Trinidad and Tobago Civil Aviation Authority who has been present in these proceedings, Ms. Sandra Warner, who is the Corporate Secretary, is in the waiting room and has been in the waiting room to come in. So if she can be let in, please. Mr. Chair, this is not the document I was speaking to. However, I can speak to this and have the witness verify this one that's on the screen. Were they merged?
No, it's two separate documents.
Two separate documents. So this is the second policy that I was going to, but I will, if the panel is following me, I will, since this is up on the screen, I will ask some foundational questions for this document. Put this in, and then I'll go back to the aviation policy. With your leave, Mr. Chair.
You may proceed, Ms. Rose.
It's not that.
It's not this. It's
MV6 times.
It's the NV cert.
Yeah.
MV certs. The second tab on the top that's there. MV certs, yes. Okay. Now, Ms. Sooklalsingh, as you were saying, you are privy to the negotiations and securing of policies, insurance policies for the Trinidad and Tobago Civil Aviation Authority.
Yes.
And you are aware, can you tell us what the status of the motor vehicle insurance policy is as of now?
We received new certificates for the period October 1st, 2024 to September 30th, 2025 on September 26th of 2024. We received all of the new certificates on the 26th of September.
And you see up on the screen a certificate of insurance for motor vehicle insurance, third-party risk, under the Third-Party Risk Motor Vehicle Insurance Third-Party Risk Act, certificate number 494882, policy number MOGCT 231197. Yes? Is that, what period of time is that policy cover for?
October 1st, 2024 to September 30th, 2025.
And can we go to the bottom of the document? And so you are seeing the document. Are you in a position to confirm that this is the certificate of insurance for motor vehicle insurance cover?
Yes, I can confirm.
Yeah. Mr. Chairman, I would like to tender this document as RS1. Is that sufficient for?
Noted, Ms. Rose.
Thank you. There is another document, please, Mr. Chair, which is the certificate of insurance for aviation insurance cover, which was also submitted in the documents on Friday. If the team can pull that up, please. Yes.
On screen,
yes.
There's a document with WTW at the top.
Yes, please. That is it. Now, Ms. Sooklalsingh, you also indicated that you were familiar with the aviation insurance coverage that was secured.
Yes.
You see on the screen the certificate of insurance from WTW, reference number 2024/AERO/TTCA/0001.
Yes.
Are you in a position to confirm, and if we can scroll right down to the end of the document, that this is insurance coverage that was negotiated for the period 1st of October 2024 to 30th of September 2025?
Yes, it is.
And when did you come to have knowledge of this?
This certificate was forwarded to us on September 30th, 2024.
And would you have been privy to anything that would have happened prior to September 30th, 2024 for this to be secured? For this insurance cover to have been secured, did TTCA take any step or action?
Yes, because the the policy covering the period October 1st, 2023 to September 30th, 2024, that policy would have expired on September 30th. The authority sought to renew its insurance coverage for aviation liability post the evaluation and award of contract.
Now, we've also, Mr. Chair, submitted certain documentation, certain correspondence. Now, at some point in time, you became aware of steps that the interested party, Gallagher Insurance Brokers, would have taken pursuant to the indication from TTCA that they were the successful proponent?
Yes. I believe that after the notification, Gallagher would have undertaken to mobilize to ensure that aviation liability coverage would be secured for the upcoming renewal period.
And this correspondence between Gallagher and WTW was passed to you?
Yes.
And can we scroll down? Can we just scroll through all? Ms. Sooklalsingh, can you tell us what is Ms. Sooklalsingh, can you tell us what is attached to that email? If you can scroll back up, please, to the attachment.
Okay. Yes, attached to the email was the evidence of cover that was secured for aviation liability and for motor vehicle insurance. Again, for October 1st, 2024 to September 30th, 2025.
And can you tell us why such cover was important to the Trinidad and Tobago Aviation Authority?
The expiry of the aviation liability on September 30th would have left the authority vulnerable to and exposed to a number of different risks. So in the out of an abundance of caution, the authority sought to renew its aviation liability policy, but we were not exposed unnecessarily, and on the aviation liability side, and on the motor vehicle side, the authority has a number of air navigational equipment sites throughout Trinidad and Tobago in order to access those sites for routine maintenance and to address any emergencies or incidents in those areas. The motor vehicle fleet would have been necessary to access those sites. So in particular, the aviation liability and motor vehicle were very time sensitive, and the authority could not afford a lapse in coverage in those two areas.
And why couldn't you just simply renew, extend it for a month?
With respect to the aviation liability in particular, because of the value of the sum insured, the sum insured is $250 million US. Overseas markets are very unwilling to take on a month-to-month basis type of risk. Right?
1 minute. I think I saw Ms. Fitzpatrick's hand raised.
Yes. Yes, Ms. Rose, I recognize you, Ms. Fitzpatrick.
Yes, sorry, Mr. Chair, I know that the purpose of the oral examination was put in these documents, but I'm just concerned that we're going beyond the scope of what was permitted by the application on Friday. We have these additional documents. There's already evidence as to the risk and the potential risk of lapse and why and so on. But I don't know that or unless that was a misunderstanding on my part, in which case, of course, I stand corrected. But perhaps the panel will recall.
Thank you, Mr. Fitzpatrick.
Mr. Chair, this evidence is being led, pursuant to all the information so as to be able to make a fair and just assessment.
Ms. Rose?
Yes?
Excuse me,
Yes?
your connection seemed
Mr.
to have dropped. We did not get your last. Your connection seems to be dropping.
Yes, I apologize to the panel for this. Mr. Chair, this evidence is in through other witnesses. It was just to be comprehensive in respect of this witness now giving this documentation to put it in here as well. If Ms. Fitzpatrick objects to that, I have no difficulty in not providing that holistic understanding of the documentation. I think our evidence from other witnesses is quite comprehensive on the urgent public interest consideration. So it was just to be complete in respect of these documents. So I will not press it if Ms. Fitzpatrick has a problem with it.
Noted. Ms. Fitzpatrick?
I'm grateful to my friend.
Thank you, Ms. Fitzpatrick.
And Mr. Chair, in terms of the additional documentation and the questions pertaining to SEAM, we are at an end now, and so I would like to tender this witness for cross-examination.
Thank you, Ms. Rose. Ms. Fitzpatrick?
Thank you, Mr. Chair. Ms. Sooklalsingh, I'm going to ask you some questions now. If for any reason you can't hear me, please ask me to repeat myself. And your answers, of course, are being recorded. So please speak as clearly and loudly as you can for the record. Yes?
Yes.
Okay. You were appointed the chairperson for the evaluation of this RFP 05 of 2024. Is that correct?
Correct.
And as such, you are well familiar with its terms, yes?
Yes.
And specifically, you are familiar with the evaluation criteria and the methodology that's set out in the RFP, yes?
Yes.
And the RFP sets out evaluation of proposals almost in 3 stages, if I'm not wrong. The first stage is really that the proponents must meet the mandatory requirements, being provision of certain documents, yes?
Yes.
And all 3 proponents passed the mandatory requirement stage.
Yes.
So that they then moved on to the second, being the technical evaluation. And thereafter, the third part is the commercial evaluation. Yes?
Yes.
So I'd like to move just to deal with the technical evaluation. Technical criteria under this RFP is considered non-price. Is that correct, Mr. Sooklalsingh? It's not correct. It's not evaluating the price. Yeah. And if
it's not.
Good. If I might take you, please, Mr. Chair, I would appreciate the IT's assistance with pulling up Ms. Sooklalsingh's witness statement, please. I'm looking at page 4, paragraph 9 on page 4.
Mr. Chair.
Ms. Rose?
Mr. Chair, I'm uncertain as to where my learned friend is going with this because no issue has been raised and there is no issue before this honorable panel relating to the technical evaluation. And so there is in your hearing rules that the panel must confine itself to issues raised between the parties. So I'm asking council to establish the relevance of this question to the issues raised. So I'm objecting on the grounds that it's irrelevant to the issues raised.
Ms. Rose, do you wish the witness to leave the room?
Oh, Mr. Chair, did you not hear my objection?
Yes, Ms. Rose.
Mr. Chair.
We heard your objection and I'm taking the opportunity to discuss with my panel members. However, I'm asking you if you wish your witness to leave the room while we're having discussions. Because we would break shortly to discuss and then we would get back to you.
Yes, it would be Ms. Fitzpatrick if I have no problem with the witness being here. But I have already made my objection in the presence of the witness, so.
Okay, noted, Ms. Rose.
Mr. Chair, one last thing before you go. At the beginning of the morning, my client, TTCAA, had asked us, because of the problems we were having with internet connectivity in this room, we were actually calling the OPR this morning, but we didn't get through, to move to another room where they assure that the internet connectivity would be better. Could we take the opportunity while you are conferring with your team to move to another room, please?
Ms. Rose, that is amenable to the team.
If we can be given 5 minutes.
You may take 5 minutes to move to a more suitable location.
So 10.
We are respectfully asking for 10 minutes. Apologies.
10 minutes. Ms. Fitzpatrick?
Yes, sorry. I think it's probably best if I just say this before the moving. I would appreciate if the witness is not present while we're dealing with this objection, please, Mr. Chair. So perhaps when the movement takes place,
Objection.
we'll take into account.
Okay. Noted, Ms. Fitzpatrick. Ms.
No
Sina?
objection.
Yes, please, Mr. Chair.
Any contribution with regards to the witness and the time?
No, please.
Okay. Ms. Fitzpatrick, is your hand still up?
No, it's not, Mr. Chair. I have some problems using this button, but no, it's not.
Okay, noted. So we would resume in 10 minutes.
I'm sure you won't have any problems there, right?
No, it should be okay.
Okay. It should be okay. Oh,
Yeah, 95%.
Like,
this is yours? Yeah. It is.
Participants, we are ready to continue.
Mr.
I
Chair,
am just some housekeeping before we continue, Mr. Fitzpatrick. I'm seeing the machine for Dana Marie Smith. The camera is off. Thank you, Ms. Smith. Ms. Fitzpatrick, you were saying something just before we close?
yes, please, Mr. Chair. I'm not sure whether I will be given an opportunity just to respond to my friend before a decision is taken, please.
You may proceed, Ms. Fitzpatrick.
Thank you, Mr. Chair. Mr. Chair, my friend has raised that this is not an issue which is set out in the applicant's Form 8. And well, strictly speaking, that is the case. The reason why is because when this application was filed, the applicant had no information about how the evaluation was in fact conducted, so that the application is based at least on one ground, that we were the most competitive bid. The respondent has now come and given evidence to say, we made a mistake, yes, you were the lowest bid, but in any event, you would not have been successful. That is essentially what Mr. Sooklalsingh's witness statement is setting out, that in any event, commercial proposal aside, on the basis of the technical evaluation, Gallagher would have ranked first. That is the essence of the witness statement. So that we say that this issue actually arises on the respondent's case, and it would be wholly unfair to not be entitled to cross-examine this witness on her evidence. The RFP is before you. This is not something, again, that the evaluation report and the criteria applied is not something that would have been within the knowledge of the applicant at the time of filing the Form 8. And I'll remind the panel, please, that the respondent has been allowed to introduce a new issue into these proceedings, which was not raised in its Form 9, that being those rights of innocent third parties, which of course those issues would have been known to the respondent at the time that the Form 9 was filed, unlike the situation that has arisen here. In any event, please, Mr. Chair, we also say that this is an issue that was raised even in the submissions, in the skeletal submissions of the applicant at paragraph 32, which is on page 8 of those skeletal submissions. We say, having seen the Form 9 and having seen the evaluation report that was disclosed at that stage, it is clear that AIB's, Gallagher's, and 21st proposals were assessed by the evaluation committee using a quality and cost-based selection method, where the technical proposal was weighted 80% and financial was weighted 20%. There was, however, no provision in the RFP which provided for the use of this methodology and criteria in evaluating the proposals. In these circumstances, we say that the Civil Aviation Authority is in breach of the evaluation regulations. So I find it surprising that this objection is being taken now.
Thank you, Ms. Fitzpatrick. The panel will now give its decision on the objection made. And having discussed the matter, we are allowing Ms. Fitzpatrick to continue with her line of questioning. Before we do continue, however, some housekeeping matters again. Ms. Rose, Ms. Sooklalsingh will be joining online when we are letting her back in the room, as opposed to being in your room.
Sorry, we're having technical difficulties here. But yes, Ms. Sooklalsingh is not in the room with me at the moment. She will be joining me as soon as the hearing panel gives leave. And yes.
Thank you. So we are ready to proceed. We are giving leave for Ms. Sooklalsingh.
Mr. Chair, may I proceed?
May I proceed, Ms. Fitzpatrick?
Thank you. Mr. Sooklalsingh, welcome back. Before we took the break, you confirmed to me that the technical criteria is non-price criteria. Yes? And I was taking you to paragraph 9B. So IT, I need to just go down to page 4. Yes, you can stop it. Yes, this is paragraph 9B of your witness statement. And you say here that proposals that were deemed compliant, and when you say compliant, you mean with the mandatory requirements, correct?
I'm so sorry, I didn't get that entire question. The speaker was lowered. Could you repeat?
Oh, I'm very sorry. Okay, so I've taken you to, can you see on the screen?
Yes.
That is a paragraph from your witness statement. You recognize that?
Yes.
Right, so that's paragraph 9B. And I was asking you, that first sentence says, proposals that were deemed compliant were accepted for technical evaluation. And what you're saying there is, when you say deemed compliant, you mean proposals that were deemed compliant with the mandatory requirements.
Correct.
So all of the proposals were accepted for technical evaluation, yes?
Yes.
And this was on the basis of the predetermined evaluation criteria and scoring system shown in item 6 above. And
Yes.
if we can go back, please, IT, to page 2, it's paragraph 6. Yes, stop there, please. Mr. Sooklalsingh, do you see paragraph 6 there?
Yes.
And that is what you're referring to?
For the
Yes,
technical
that's,
evaluation.
yes. So when you said item 6 above, you were talking about this paragraph 6.
Yes.
Yes. Okay. And this says the evaluation criteria identified and utilized in RFP 05 of 2024 was, and then we set out company profile and experience. You have the points there, methodology and approach, the points, administrative capability, 18 points, etc. Yes?
Yes.
Now, the predetermined criteria you referred to in your paragraph 9B is that is utilized in the RFP, yes? So that if we go to the RFP, I'm going to have to get the page for IT. And this is of what Mitam's. So of the refiled bundle, is this tabs 1 to 7? Can I ask you just, yes. So if we go to page 3, we should see the beginning of that. Page 11 is what I'm looking for, please, I think. It will be a table. Yes. So, Mr. Sooklalsingh, what you set out in your witness statement at item 6 is essentially this evaluation criteria and scoring system.
Yes.
Yes? And this is a weighted system, correct?
Yes.
Each of the proponents we know passed this stage in that they all got 50% or more in each of these technical criteria categories, yes?
Yes.
And they also got more than 75% overall in this scoring system.
Yes.
And if I could take you, please, to paragraph 17B. So I see if we can just scroll up, please, to 17B. Yes, so let's stop a little further down. Right. So those were the technical specifications that we just looked at, correct? Yes, those were the technical specifications. So I'm looking now at evaluation of technical specifications because we've just established the preliminary examination everyone has passed, right? says each submission deemed substantially responsive during the preliminary examination stage shall be subjected to a technical evaluation to ensure that the proposed, and this has to be a typo, services meet the requirements outlined in the RFP. The technical evaluation shall be conducted on a pass-fail basis. You see that?
Yes.
So that means, Mr. Sooklalsingh, that once they achieve minimum 50% in each of those criteria and 75% overall, they pass the technical evaluation. Isn't that what that means?
Yes.
Thank you. So I would like to take you, please, to your page 7 of your witness statement, table 4. Thank you, yes. So if we look at this table 4, just above it, it says the technical and financial commercial scores were normalized to rank the proposals identified and identify the top ranked proponent. Your table 4 has a number of rows and columns. The first row we see, I beg your pardon, the first column, we see the vendors listed. Then we see technical evaluation. We see some scores there. And those, you can correct me if I'm wrong, are the scores out of 100 based on the table that we looked at in the RFP, correct?
The first table, yeah. The first column, yes.
And then next to that column, we see a column that says weight.
Yes.
Yes, and that says 80. And Mr. Sooklalsingh, this is where the applicant is having difficulty. You just confirmed for me that the technical criteria is pass-fail, yes?
Yes.
And if you're able to correct me, there's nothing in the RFP that says that the technical evaluation will be weighted 80%.
Correct.
Thank you. And you will agree with me then, Mr. Sooklalsingh, that the proponents were not aware that this was the criteria that was being applied to the technical evaluation.
Could you clarify that question? Could you provide some clarification?
Yes, the proponents were not aware that you were applying a weighting system with respect to the technical evaluation, it having not been included in the RFP. They didn't know.
I believe the RFP did indicate the upper part of 17, I believe, the RFP did indicate that it was a weighted evaluation criteria. The weightings.
Well, hold on, Mr. Sooklalsingh. I want to be fair to you. Let me show you what that says. Can we go, please, to page, it will be page 10 of tab 1, please. Sorry, so I need you to scroll up, please, to 17, where 17 starts. Yes. So, Mr. Sooklalsingh, what you were talking about, I believe, is that under evaluations of proposals, it says proposals shall be subjected to a combination of pass, fail, or yes or no, and weighted evaluation criteria. Yes?
Yes.
And you showed me that the evaluation criteria and scoring system was weighted. Yes? Where we had the numbers, the scores out of 100. I asked you whether that was a weighted system and you said yes. You remember that?
Mm-hmm. Yes.
And I then asked you whether you agreed that the technical specifications based on what is said in 17B would be conducted on a pass-fail basis. And you said yes. Correct? Is there anything in this RFP, Ms. Sooklalsingh, that says that the technical evaluation will be weighted 80% of the overall score? That's my simple question.
No.
Thank you. And I'm saying to you, Ms. Sooklalsingh, that that is not fair to the proponents. Do you agree with that?
I believe the upper part of 17 would have indicated
Ms.
that.
Sooklalsingh, my question was whether it was fair or not. You can agree, you could say yes or no.
I believe it was fair.
Okay. So I'd like to move on now. In your witness statement, Ms. Sooklalsingh, at paragraph 7, you refer to the OPR evaluation of bids and contract guidelines, section 3.8.
Mm-hmm.
Yes, you read that document, Mr. Sooklalsingh?
I would have referred to the area that listed the types of methodologies available.
So you didn't read the whole document?
I would
No,
have referred to the part that listed the types of evaluation methods available.
Okay, so you would not have seen, do you recall seeing section 3.2?
No.
Section 3.2 of that document that you have referred to, Mr. Sooklalsingh, says on page 40.
We referred to section 3.8 here.
Yes, so I'm telling you something. It says the procuring entity shall select the successful bidder based only on the evaluation criteria and methodology specified in detail in the bidding documents. That is not what civil aviation has done here. Do you agree with that?
I can't say without actually seeing section 3.2.
Well, I've just told you what it says. It says they shall only select a successful bidder based, it actually says based only on the evaluation criteria and methodology specified in detail in the bidding documents.
Am I on?
Yeah.
Ms. Rose? Yes, Ms.
To be
Rose.
fair to the witness, please, Mr. Chairman, may the witness be shown paragraph 3.2 to which Ms. Fitzpatrick is referring.
Yes, we are locating the document to present shortly.
Mr. Chair, I actually don't know that the document forms part of any of the evidence, because although it's referred to there, I don't know that Mr. Sooklalsingh's witness statement attaches it. So I really don't need to press this. I believe I'm happy to move on unless my friend would prefer that I could find the document, but.
Ms. Rose, have you noted the comments of Ms. Fitzpatrick? Do you wish to continue?
Mr. Chair, we're having a bit of a technical difficulty here, turning down the volume on one computer. So I didn't hear all of what was said. However, I'm simply stating that to be fair to the witness, if a portion of a document is being put to the witness and the witness is saying, well, I don't know because I haven't had an opportunity to see it, it is only fair that it should be shown it. And I would say, since this is the Office of Procurement Regulations' own guidelines and procedures, it could be readily available. However, if my learned friend is moving on from the point, we do not need to put it up before the witness.
Okay. Noted, Ms. Rose, and the documents are indeed part of our guidelines. Ms. Fitzpatrick, do you wish to continue?
If it is in fact easy to pull up the documents, then by all means, I didn't want to make it difficult for anyone to find. So what I'm looking for, if we are able to identify that document named in Ms. Sooklalsingh's witness statement, it's the Office of Procurement Regulations Evaluation of Bids and Contract Guidelines. And I am looking at page 14.
Okay. Thank you, Mrs. Patrick. The team is looking for it and will be bringing it on the screen shortly. Before we proceed, though, Ms. Sooklalsingh, we have noted that you appear to be looking to your left or speaking to someone on the side. Are you alone in that room? Or is it the same shared room as Ms. Rose?
Yes.
And I can assure the panel that there is no discussion whatsoever going on.
Just to confirm, it's the same room that you're both in?
I didn't hear that entire
The panel was noting that it appears that you were either referring to someone or in conversation with someone to your right or your left. We just wanted to confirm that you were indeed alone.
I'm not alone. I'm in a shared room.
The same room as Ms. Rose and the
Yes,
IT team?
correct.
Okay,
Yes.
noted. The document is now on screen. Ms. Fitzpatrick, you may continue.
Yes, so we see here under the document that you have referred to, we see section 3.2, and I am looking at page 14. I believe it's at the bottom of 14. So there we see yes, there, thank you. We see the characteristics of, can we just scroll up a little bit, please? Yes, characteristics of evaluation, of effective evaluation criteria. The document sets out that the evaluation criteria should be completed prior to the solicitation of bids, should not be altered after the opening of bids, should be applied equally and uniformly in the evaluation of proposals. And then the final line says, the procuring entity shall select the successful bidder based only on the evaluation criteria and methodology specified in detail in the bidding documents. And if we go down, we scroll down and then we stop there. And then there's a big note that says, under no circumstances should new or revised evaluation criteria be introduced during the evaluation of bids. It is recommended to consider carefully the method used for selecting the best offer and ensure the suppliers are requested to provide all the information that might be needed to fully evaluate their bids. And what I'm asking you, you are the chair of the evaluation committee, is having now seen this document, do you maintain that the criteria that was applied was criteria that was set out in the bidding document?
Can you repeat that?
Do you maintain that the criteria that was applied in evaluating the proposals was that which was set out in the bidding document?
Yes.
Okay, so we're moving on now. Ms. Sooklalsingh, which company submitted the lowest financial costing?
During the evaluation, it was, well, during the lead up to these proceedings, we realized that there was an arithmetic error, as I would have disclosed in my witness statement, in one of the cells of our worksheet, right? So previous to this, Gallagher would have achieved the lowest cost proposal, right? In correcting that error, Agostini would have now achieved the lowest cost proposal.
Okay, so the short answer is Agostini Insurance Brokers submitted the lowest financial costing. Thank you. And we know that that is not reported in the evaluation report because, as you say, there was this arithmetical error. And I believe it was explained, or it was, we figured out while Mr. Mitchell was being cross-examined that that was because you doubled some figures.
Yes, it was a formula error in one of our worksheets, and that has since been corrected.
Yes, and that resulted in the bid being stated as over $1 million higher than what it actually was, correct?
For the cost proposal, I'm not sure if it was over $1 million.
That's correct.
Yeah.
Mr. Sooklalsingh, I believe I am incorrect to say that, so I apologize. But we accept that Agostini Insurance Brokers Limited did in fact submit the lowest bid. So I'd like to take you back to your table 4. Okay, let's stop there. So we see we've already dealt with technical, so we're moving on to look at the commercial score. In the column just before commercial weighted score, we see weight, yes? And it says 20.
Yeah.
And what you're saying there is that commercial proposals in the evaluation report were weighted 20% of the overall score.
Yes.
And there is nothing in the RFP that says that the commercial evaluation will be weighted 20%. Do you agree with that?
Yes.
Okay. Now, IT, I'm sorry, I'm going to go back now to the RFP itself. The page that we were at previously, which was 11, page 12 actually, page 12 of this PDF. Yes, stop there, please. That's at 17D. Okay. So 17D, evaluation of commercial proposals, says only proposals that pass the technical criteria, having earned at least the minimum attainable score of 50% in each of the 4 evaluation criteria and at least 75% overall, will be, and I think it should say eligible for further evaluation. And we accept that all 3 proponents have passed.
Yes.
On completion of the technical evaluation, the commercial proposal of proponents that pass will be considered and evaluated. The commercial proposal of all proponents that passed the technical evaluation stage will be reviewed to ensure that all activities required in the scope of services were priced and that there were no arithmetical errors in the proponent's commercial proponents. And then it says in the event of discrepancies. Yes? So,
Yes.
Mr. Sooklalsingh, based on the criteria as set out in the RFP, you accept that Agostini Insurance Brokers Limited would have passed the technical evaluation, correct?
Yes.
And you accept that they submitted the lowest commercial price, correct?
Yes.
And therefore, I'm saying to you, Mr. Sooklalsingh, that they would have been ranked first on the basis of the RFP criteria. You agree with that?
No, I don't.
And the reason you don't agree with that is because you say that the weighting can be read into the document, the weighting system that you've applied.
The weighting system was indicated in part 17 of the RFP.
Mr. Sooklalsingh, I just showed you where the technical evaluation is pass-fail. I showed you that, and you accepted that that's what is said in the RFP, yes? So let me ask you this question then. Did you, in evaluating the proposals, treat the technical criteria as pass-fail?
The technical criteria was...
Mr. Sooklalsingh, I'm asking you a yes or no question. In evaluating these proposals, we have just looked at what the technical criteria says. It says pass-fail. Once you achieve more than 75% overall, you move on to commercial. Did you apply a pass-fail system when you were evaluating the technical proposals?
Yes.
Yes, you did.
Yes.
And this table that you have set out in your witness statement, table 4, does not say that. It does not say pass. Does it? It says wait.
Yes, it says wait.
Okay, so I'm saying to you that in evaluating these proposals, the respondent applied criteria that was not set out either in detail or at all in the bidding document. You accept that, yes or no?
The 80-20 percentages you
You
refer to.
accept that was not set out in the RFP.
Yes.
Thank you. Mr. Chair, can you just bear with me one moment? Mr. Chair, I have no further questions for this witness.
Thank you, Ms. Fitzpatrick. Interested party, do you have questions for the witness?
Mr.
No,
Chair?
please, Mr.
Am I being heard?
Yes, Ms. Rose. Ms. Rose? Yes?
We're not hearing what's up about the
Are you hearing me, Ms. Rose? Seems so. Other participants, are you hearing me?
Apologies. Because we have two computers in the same room, we are juggling turning off the audio on each computer. So I heard nothing of what you may have said a few moments ago. Mr. Chair, I would like to redirect, please, re-examine with your leave.
Please proceed, Ms. Rose.
You go. Okay.
You indicated to my learned friend when you were referred to the Office of Procurement Regulation, evaluation of bids and award of contracts, that you still were of the view that the evaluation process was fair. The technical evaluation
Yes.
was, yes. Can you explain why you have that view?
Because we would have looked at each criteria set out in the RFP. We would have looked at each sub criteria and assessed according to the information that was provided in the RFP and scored accordingly. Further to the technical evaluation, the financial proposals contained costing for both general and group health and life components. The general as well as the group health and life components, there were options submitted by each component for the group health and life proposals. In order for each proponent to be treated as fair and as equitable as possible, we would have chosen the cost proposal that matched our current schedule of benefits, as well as the administration of the plan. So the administration of the plan would have been backed by an insurer. So in order to level the playing field and normalize or compare like with like, we ensured that each proponent was treated fairly, especially in the case of group health and life.
Right. So, but I want to deal specifically with the issue that was raised by Ms. Fitzpatrick in respect of the 80-20 detail of the weighted evaluation criteria between the technical and commercial. Ms. Fitzpatrick has her hand raised, please, Mr. Chair.
Mrs. Patrick? You unmute, Mrs. Patrick.
I'm sorry. My learned friend has re-examined the witness quite properly, asking her why she answered a particular question asked of mine in a particular way. The witness has given an explanation, and my friend is now going back to say, well, no, I'm talking about something specific, which the witness did not raise in her response at all to my question. So I take objection to this line of re-examination. The witness has given an answer.
Well, may I respond to that? Okay, may I respond to that?
Ms. Rose?
I would say perhaps my question was not clear enough, because my question on redirect, as properly it ought to be, was related to the specific questions that Ms. Fitzpatrick raised in respect of the OPR evaluation guidelines that were put to the witness. So I think my question should have been more specific. Please, Mr. Chairman.
Would you like to restate your question, Ms. Rose?
Yes, please.
Proceed.
Ms. Sooklalsingh, my learned friend, Ms. Fitzpatrick, put to you that the process was not fair, and asked you why you believed the technical evaluation was not fair, having regard to why you believe the technical evaluation was fair, having regard to the fact that the 80-20 weighting was not specified in the RFP. Why do you believe it was fair?
I think in regards to specifically the group health and life proposals, the costing proposals, because of the number of different options that were placed before the evaluation team, we felt that the comparing like with like in this respect was the fairest and most equitable treatment of all the proponents. All right, so the team utilized the cost option that matched the current schedule of benefits and a backed insurance administrated plan.
I have nothing further for the witness.
Representative for the interested party, do you have any questions of the witness?
No further questions for this witness, please.
Thank you, Ms. Seenat. Is that it for this witness? Ms. Seenat, I recognize your hand before I continue.
Honorable panel, I just need to step out the room for 2 seconds. May leave be granted, please, at this point.
Ms. Seenat, you have 1 minute.
2 minutes. Yeah, 1
No.
minute. Yeah.
Because 120 seconds.
Mr. Chair, can Ms. Sooklal, oh, they're gone.
Still here, Ms. Rose? Yes, you have a request?
May Ms. Sooklalsingh be relieved?
When Ms. Seenat returns, we would relieve her and continue.
Very well, please.
Thank you for your indulgence, honourable panel.
Thank you, Ms. Sinat. Just confirming, you have no questions to pose to the witness?
No further questions, please. Thank you.
Before the witness is relieved, the panel does have a question to the witness. Ms. Sooklalsingh, in paragraph 9E of your document.
Just one.
I would give you some time to resolve the technical issue. At least put one mic on in the room so we would be able to hear. And you would be able to hear us clearly.
Are you hearing me?
Yes, we are hearing you clearly now. Great. Ms. Sooklalsingh, that paragraph 9E is visible there. Could you explain to the panel what the term normalized means? The technical and financial commercial scores were then normalized to rank the proposals and identify the top rank proponent.
Normalized in reference to this table would mean to compare like with like.
So that basically, thank you, Ms. Sooklalsingh. This witness is now relieved, Ms. Rose.
Grateful, much obliged.
Mr. Chair, just one matter of
Yes.
housekeeping, please. I would just like to indicate to my learned friend that I will not be cross-examining Ms. Williams, Ms. Tiffany Williams.
Noted, Mr. Patrick. Ms. Rose, your next witness, please.
Would the panel require Ms. Williams for questions?
Yes, we will.
Well, I'll call Ms. Williams next, please.
Okay. Is Ms. Williams present?
If we're supposed to be in a room outside, Mr. Chair.
We will give you a moment to allow your witness to be present.
Thank you, please, Mr. Chair.
We take it that the person present on Ms. Smith's laptop is Ms. Williams.
Correct.
Yes, please.
Thank you.
Good morning, Ms. Williams.
Hi, good morning.
Good morning. Could you please repeat after me?
So,
I,
I,
please state your name,
Tiffany Williams,
do solemnly,
do solemnly,
sincerely,
sincerely,
and truly affirm
and truly affirm
that the evidence I shall give to the hearing panel
that the evidence I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
No, I turn to the witness for cross-examination, please, or for questions by the panel.
Interested party, do you have any questions for this witness?
No, please.
There being no questions by the applicant's representative and by any interested party, this witness is now relieved.
Okay. Much obliged.
Next witness, Ms. Rose.
We call Mr. Mitam Narsingh. Mr. Mitam Narsingh is present, please, Mr. Chair.
Thank you, Ms. Rose.
Please repeat after me. I, please state your name,
Mitam Narsingh,
do solemnly, sincerely, and truly affirm
do solemnly, sincerely, and truly affirm
that the evidence I shall give to the hearing panel
that the evidence I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
The witness is tendered for cross-examination.
Ms. Fitzpatrick.
Thank you, Mr. Chair. Good morning, Mr. Narsingh. Are you hearing me?
Good morning. Yes, I am.
Okay. Mr. Narsingh, you, in your capacity as the respondent's procurement officer, are familiar with the provisions of the Procurement Act, of the Public Procurement and Disposal of Public Property Act 2015 as amended. I think it's right to give you the full name. You familiar with the provisions of the Act?
Yes, I am.
So you are familiar then with the purpose of the legislation, yes?
Yes.
What do you understand that to be?
Basically, that all procurement activities should be fair and transparent and objective, basically achieving the objects of the Act.
Yes. And the inclusion of a standstill period in the tender process is part of how you achieve fairness in the procurement. Do you agree with that?
Could you elaborate?
Okay, well, let me ask you this. what is the standstill? What is the purpose of the standstill period as you understand it?
Basically, to allow any proponents to inquire about the decision to award.
Well, the intended decision to award. Yes?
Correct. Yes.
It gives them an opportunity to raise an objection.
Yes.
And in that way, it ensures that there is some level of fairness in the procedure. You agree with that?
Yes.
Yes. Now, I'd like to take you to the RFP. IT, I'm looking, please. Well, first of all, Mr. Narsingh, the respondent is responsible for preparing the RFP, correct?
Correct.
Did you have any part in preparing this RFP?
Yes, I did.
Okay, so then you're very familiar with the relevant provisions. But I'm going to ask that the IT personnel pull up paragraph 10, please. I'm just going to go through some of these parts so that we get a sense of what the RFP actually says. It's IT. IT, that's tab 1. Sorry. I actually think there's an error in the tabbing. It's PDF 3 of tabs 1 to 7, PDF page 3.
We are locating the document.
No problem. We scroll down. Can we stop there for 1 second? Sorry, just at the cover page of this document. Yes. So this, Mr. Narsingh, is a request for proposal that was provided to the proponents, correct?
Yes.
Yes, and at the front of this document, we see 05 2023 to 2024. So there's numbering included at the front of this. And if we go now to page 6 of that document, where we have provision section 10, if you want to call it yes, there. So what you've done in the RFP is you set out the instructions, and as part of the instructions, you see there at this part 10, there is provision for the clarification of RFP documents. It says inquiries with respect to the proposal document should be sent via email, and that the TTCAA will respond in writing no later than 5 days prior to the deadline for submission, and shall reply within 5 days of receiving the request to enable the proponent to make a timely submission. Right? So it seems here, Mr. Narsingh, that there is contemplation that there will be some 5 days from receiving requests for clarification for response. Yeah?
Yeah.
And if we go now to page 7 of that document at the top, that's page 6. Can we scroll down a little bit more? So I'm looking, yes, at the top of that page, page 7, all proponents who have obtained. Yes, okay. So here you are telling the proponents through the RFP, you see the 3rd paragraph there, in order to allow all proponents reasonable time in which to take the addendum into account in preparing their proposals, Civil Aviation at its discretion may extend the deadline for submission of proposals. So you see there that what the RFP contemplates is there will be, or there should be time, if necessary, to extend the deadline for submissions for proposals. You agree with that?
Yes.
And if we go to page 10 of the RFP, paragraph 18. That's negotiation of contract. Civil aviation reserves the right to enter into discussion and, as appropriate, negotiate with the top rank proponent to clarify, among other things, scope of services, etc. Should the negotiations with the top rank proponent fail, the discussions would be formally terminated, and the commercial proposal of the next rank proponent will be opened, etc. Negotiations will be conducted with the next rank proponent, and so on until a contract can be successfully negotiated. So this part 18 of the RFP contemplates that there may even be a period of negotiation. Yeah? Before a contract is awarded. Do you agree with that?
Yes.
And then if we go a page over, paragraph 19, the award of the contract. Following the successful negotiations, the contract will be executed. And the second line of that 19, or the second paragraph rather, says the successful proponent and civil aviation shall make every effort to execute the formal contract within 14 days from the date of the letter of award. You see that?
Yes.
If I could take you to these final parts of the RFP, I want to show you are on page 16. That's paragraphs 27 and 28, so parts 27 and 28. Validity period. The proposal shall be valid for a period not less than 120 days from the date of closing date of the submission, for the submission of proposals. Civil aviation, in exceptional circumstances, reserves the right to request all proponents to extend the validity period of the proposals. So it also contemplates that there may be a need to extend the validity. Yeah. And then, of course, the part of the RFP, which is a major subject of contention in these proceedings, is a standstill period there. A standstill period of 10 days shall commence the day following the notice of decision to award. During this period, any unsuccessful proponent wishes to challenge the outcome of the procurement process may file an appeal in accordance with the procedure outlined in section 50. And you will agree, therefore, that this RFP contemplates that there should be a standstill period of 10 days, yes?
Yes.
And when the respondent, that civil aviation, was setting its internal timelines, it would have taken into account those matters or those parts of the RFP that we looked at, correct?
Could you just elaborate?
I've just shown you that the RFP contemplates certain time periods for different things, whether it's negotiation, whether it's the standstill period, whether it's extensions of time. I'm asking you whether, in setting its internal timelines, the respondent would have taken those matters into account.
Yeah. Yes. Can I add to it?
No, if there's any need for you to elaborate, the counsel for the respondent will re-examine. My question was a yes or no question, and I understood your answer to be yes. Now, I would like to look at the chronology of events really since when the bids were first opened. Okay, so we have the virtual opening on the 5th of July. And the brokerage contract for general insurances, Mr. Narsingh, is coming to an end when? Do you know off the top of your head?
General insurance will expire September the 30th.
The brokerage contract?
Oh, sorry. Which one you're referring to? Because previously it was by different brokers.
Okay, yes, and I'm telling you for general insurances, not for health and life. I'm asking about the general insurances contract. Are you aware of when that was coming to an end?
I believe it's sometime in August.
You believe it's sometime in August. Will you take it from me that from the documents disclosed by the respondent, it was the 7th of August? Or would you like me to show you where that is?
But that sounds familiar.
That sounds familiar. Okay. So the bids having gone in on the 5th of July, you accept that it took almost an entire month for the evaluation report to be completed?
Yes.
Now, Mr. Narsingh, you have not actually given any evidence in your witness statement about any decision being communicated to you to waive the standstill period anytime in August. You haven't said any of that in your witness statement. But are you aware that Mr. Felix Pearson says that a decision was arrived at on or around the 5th of August?
Yes.
You know that that took place? You were not present at that meeting, so I'm asking whether you know.
Correct.
And the reason that that decision was arrived at, according to Mr. Felix, was that there was not enough time to complete the procurement process without risking a lapse in the insurance policy and insurance coverage. And for that reason, it was waived. Did you understand that to be the reason?
Yes.
Now, just to be clear, as at the 5th of August, the evaluation report you've already seen, yes? You've already
Yes.
seen it.
Mhm.
And you've seen that Gallagher is ranked first.
Correct.
So completing the procurement at this stage, Mr. Narsingh, involves awarding the contract, doesn't it?
Yes.
Okay. And you're also aware then that the award of the contract does not take place until the 16th of August.
Yes.
And the letter of appointment to the interested party, which authorizes it to begin negotiations, etc., is issued on the 29th of August, 2024. Yes?
Yes. Mhm.
But there was more than enough time in there for the standstill period, Mr. Narsingh, wasn't there?
Can you elaborate?
Well, I've just shown you, we've just gone through the timeline. Yes? You receive the evaluation report on the 2nd. The decision is taken on or around the 5th. Yes? And then almost 10 days passes, which by the way is what the standstill period would have been, before the award of the contract is made. Another, and I don't want my math to be wrong here, 13 days passes before the letter of appointment. So I'm just asking you, or I'm saying to you actually, that there was more than enough time in there for the standstill period to be adhered to. You agree with me, yes or no?
No.
Okay. Now, you are the person who had been communicating with the suppliers up to the time that the proposals were submitted, yes?
Yes.
Yeah, so you were sending the addenda, answering their clarification questions and so on. Now, I'd like to show you some emails exchanged between yourself and the applicant. IT, we'd like to go please to page 63, PDF page 63 of Mr. Mitchell's witness statement.
We're working on it, Mr. Patrick.
Thank you, Mr. Chair.
So that, Mr. Patrick, if you're speaking to us, you're still muted.
So I'm sorry, Mr. Chair, I was saying to IT that it is actually Mr. Brent Mitchell's witness statement that we're looking at, PDF 63.
The document is now up, Ms. Fitzpatrick. Page reference again, please.
Sorry, I believe that page reference is incorrect. 370. 370, please. My apologies. Okay, that's not it either. I'm not sure why that is. Mr. Chair, could you just bear with me one moment, please? I do apologize, but I need to. It's my fault that it's not properly paginated. So I do need to just identify the PDF number. May I just have one moment, please?
Sure, Ms. Fitzpatrick.
IT, in Mr. Mitchell's witness statement, it is the exhibit that comes at tab D. There's A to F, and this exhibit that I'm looking for is tab D. I'm still making every effort to figure out what's going on with the page numbers, because on my end it's coming up as 370. I'm not sure why. So actually it was just below that I think the page that you had up with contingent assets. I don't know why. Yes, thank you. Okay, so I'm looking at these exhibits here. My apologies to everyone. So I'd like to go to, we just scroll 1, 2, 3, 4 pages along to just where the emails actually start. There's an email there, 29th August. Right. Thank you. Mr. Narsingh, can you see what's up on the screen?
Yes.
Yeah, okay. So on the 29th of August, this is the day that Gallagher is appointed pursuant to the award of the contract, correct?
Correct.
Yes. You see an email there from Mr. Mitchell seeking an update on the evaluation process and asking whether you have an estimated date when the evaluation process will be complete and the letter of intent issued to bidders. Now, this is the Thursday. if we scroll up, please, IT, you responded. Can we just scroll up a little? Thank you. You responded the following Wednesday, saying simply that you acknowledged and apologized for the late reply and would respond shortly. Yeah. By this date, Mr. Narsingh, by the 4th of September, you were aware who the successful contractor was, correct?
Correct.
And you were also aware that the standstill period, according to you, had been waived.
Correct.
But you say nothing about it in this email. Yeah?
Correct.
And if we go up, please, to the email before that, which is when on the 6th, so that's what, 2 days later, you respond and you say, we would like to inform you that the evaluation process has been completed and an award of the contract made. You still say nothing. You don't say who the contractor is. You don't say what the contract price is, and you say nothing about the standstill period. Yeah?
Correct.
And then if we go up, please. Thank you. And this is the 6th of September. On the same date, Mr. Mitchell responded to you saying he was quite surprised. And there he says, according to OPR regulations, before a contract award can be made, a letter of intent is remitted to all bidders advising the selected bidder. The letter also gives a notice of a stand down period, I think he meant standstill, of 10 business days to permit the bidders an opportunity to file an objection to seek clarification. Our records show that no such letter of intent was sent to our office. We urge Civil Aviation to refer to the OPR website, and he then points you to the handbook and some information on the standstill period. Yes? And if we go, you received that, yes?
Yes.
And if we go up now, please. And just to be clear, Mr. Narsingh, of course, you had the same information in your, or you possessed the same information at that time. At the 6th of September, you knew who had been awarded the contract, yeah? You knew that you weren't going ahead with any standstill period because the contract is long awarded.
Yes.
Right. On the 12th of September, so this is 6 days later, you say, good morning. Given the imminent expiration of the current contract for Insurance Brokerage Services, Civil Aviation had to expedite the appointment of a broker to ensure uninterrupted insurance coverage in order to mitigate the risks associated with aviation operations, including accidents, equipment malfunctions, and other unforeseen events in the public interest. A lapse in coverage could result in a major risk for public, significant financial liability for civil aviation, and the undermining of the public's trust and confidence in the safety and reliability of civil aviation. In these circumstances, civil aviation, in accordance with Section 35(4) of the Public Procurement and Disposal of Public Property Act as amended, was constrained to take the decision to proceed with the procurement without a standstill. Yes?
Yes.
And you're saying that that decision was a decision you took in August, 5th of August.
I was absent at that meeting, so.
But you were informed of it. I asked you and you said that you were.
Yes.
Yes. So unless what you're saying is nobody told you about that at that time.
But I wasn't present at August the 5th. You mentioned August the 5th.
Yes, but you were aware that the decision was taken on the 5th of August.
Sure. Yes.
Yes, you were. And certainly by the time Mr. Mitchell emailed you, you were aware that that decision had been taken.
Yes.
Now, there was no reason, Mr. Narsingh, why you could not have mentioned when Mr. Mitchell first emailed you that the contract had been awarded to Gallagher, was there?
Repeat that question, sir.
There was no reason why you could not have informed Mr. Mitchell when he first emailed you at the end of August that the contract had been awarded to Gallagher, was there?
My interpretation of section 35(4), as well as consulted both the legal department and the insurance.
Sorry, I'm not sure if my question wasn't clear, but what I'm asking you is whether I said there was no reason why you could not inform them that Gallagher had been appointed. So I understand what you are saying in this email about standstill. This is a separate thing I'm asking you, right? You take a decision.
Mr. Chair.
Ms. Rose?
Mr. Chair, I'm just objecting that the witness should be allowed to answer the question. And
He's
the
not
witness
answering my question.
well, Millennium Friend did not allow the witness to finish his answer. I'm asking in fairness to the witness that the witness be allowed to answer the question.
Well, Mr. Chair, I would be happy for the witness to answer my question, which I am about to repeat, but I don't know that I can just allow him to answer any question that he pleases. That would certainly, then I would not be doing my job. I have asked him a question and he's answering something else. And the question is, there was no reason when the email was first sent to him in August that he could not have informed Agostini Insurance Brokers Limited that Gallagher had been awarded the contract.
And if it please you, Mr. Chair, the witness was answering the reason.
My friend can't say that Mr. Narsingh. Mr. Chair, perhaps I should let you determine this, but I don't know if the witness should leave the room for this.
It won't be necessary, Ms. Fitzpatrick. The panel would allow the witness to continue with his way of answering, and hopefully he'll get to answering the question that you specifically asked.
Thank you, Mr. Chair.
If not, you may redirect and ask the question once again.
Yes. Mr. Narsingh, would you like me to repeat it?
Sure, yes.
You're muted. Yes. So
Is he muted? No, sir.
I wasn't hearing him when he first answered. My question to you was that there was no reason why, when the email was first sent to you, that you could not have notified Agostini Insurance Brokers that the contract had been awarded to Gallagher. And you started to answer something.
Yes, there was a reason why the Agostini was not notified.
And the reason was?
My interpretation of section 35(4).
What was your interpretation of section 35(4) when you first received that email?
Yes, if I can remember correctly, that subsection 35(2) does not apply in that regard.
Does not apply to what?
To notify the proponents.
Okay. So when you understood that to mean that if a proponent who has tendered specifically asks a question about the evaluation process, you don't have to provide them with any information? Is that your interpretation, Mr. Narsingh?
No, I meant not to provide them who were awarded based on section 35(2).
Was there any reason why you could not tell them when they first emailed you that that was your interpretation of the section, that you didn't need to tell them anything more, but be advised that the standstill period had been waived?
Again, my interpretation of section 35(4).
Well, your interpretation of section 35(4) changed on the 12th, because on the 12th, you specifically tell them, you specifically give them the reasons why. So why couldn't you have said that when Mr. Mitchell emailed you on the 29th of August?
Based on my witness statement, on August 30th, I sought legal advice and advice from the executive manager of corporate services.
Okay, but the legal advice was not to help you interpret section 35.4 because you've just said you understood that. Your interpretation, when you first received the email, was that section 35.2 did not apply.
I would object to this and, the shifting of the witness's evidence. In fact, the witness was responding the first time the question was asked. He said his interpretation of section 35.4 and that he had sought legal advice. Then my learned friend was stopping him from answering. And then I intervened, objecting, please do not stop him from answering. And the second time he answered, he only responded my interpretation of section 35.4. It is not fair to the witness to suggest that that is the only reason that he advanced at the time for the substance of his response on September 4th and 6th. So I would ask that my learned friend be fair to the witness and not put, and not abbreviate his responses.
Okay, Mr. Narsingh, maybe I have gotten a bit confused. So let's try and just clear this up. When you first received the email on the 29th of August asking you about the process, the reason that you did not indicate at that stage why or that the standstill period was being waived was what?
I would say asked and answered, please, Mr. Chair.
Well, I'm now confused because the way that my friend has summarized the evidence, I want to be clear that I'm not being unfair to the witness. Did you not say to me that your interpretation of section 35.4 was that 35.2 did not apply?
Correct.
And that was the reason that you did not say anything?
Correct.
Yes. So I'm saying to you that you then on the 12th inform Agostini Insurance Brokers Limited that a decision was taken. And
Yes.
my question was, there was no reason why you could not have said that to them based on your interpretation of the section as at the 29th of August. There was no reason why you couldn't have said to them that the standstill period was being waived on the 29th of August.
Incorrect.
Okay. You sure you were familiar with section 35, Mr. Narsingh?
I would say yes.
Because in your witness statement, you talk about the failure to publish the notice of award required by section 36. Yes, that was due to the novelty of the procedures and your lack of familiarity with that specific requirement. So you knew about section 35, but you didn't know about section 36?
Correct.
It's just a page over, Mr. Narsingh. Is it that you didn't read the act while this was taking place? You didn't remind yourself?
It was just purely an oversight.
Mr. Narsingh, I'm suggesting to you that you did not know that there was any requirement to comply with a standstill period. Do you agree with that?
Incorrect.
Can we get that question again? I'm sorry, I didn't. My learned friend is putting to the witness that he did not know that there was a requirement to comply with the standstill period.
Yes.
Okay.
And he says he disagrees with that.
Okay.
And I'm also suggesting to you that the reason that you did not, that is the reason that you did not say anything about the standstill period being waived prior to the 12th of September.
I'm objecting to that question.
That's
Melinda
not a
friend,
question, it's a suggestion.
yeah, but Melinda friend cannot put a suggestion that has no evidential basis.
Well, I have just gone through the evidence with him. He has said that he knew. He hasn't given any reason why he did not indicate that the standstill period was being waived prior to that time. If you'd like me to couch it in those terms, that is the reason that you did not indicate prior to the 12th that the standstill period was being waived. He's already disagreed. He's already said he doesn't agree. So I'm not sure what the harm is. Mr. Chair, may I proceed?
In the interest of
Hold a
time,
second, Ms. Patrick. We would take the answer of the witness. Ms. Fitzpatrick, you may continue.
Now, Mr. Narsingh, you signed off on 2 documents, which I'm going to take you to now. The attachments, please, to the witness statement of Mitam Narsingh. Sorry, I'm trying to get the PDF page for you. I want the recommendation, the PDF.
Page 54.
Page 54 of the refile tabs 1 to 7. Oh, 9 to 20, I apologize. Yes, this is the document here. Mr. Narsingh, you familiar with this document, this note to the Procurement and Disposal Advisory Committee?
Yes.
Is it that you received this document, or are you one of the persons who prepare this document? I'm just trying to get that clear.
You want one of the person who prepares this document?
You're one of the persons who prepare the document.
No, I am the person.
You are the person. I beg your pardon. You are the person. And this document dated the 8th of August. I'm sorry, panel, there's a siren passing. I'm just going to wait until it passes so that the witness can hear me. Sorry about that. Yes, and this document, Mr. Narsingh, is dated the 8th of August. And it's obviously Civil Aviation, Internal Communication. Who is the Procurement and Disposal Advisory Committee?
Comprised of the head of finance, head of legal, and your subject matter experts.
Right, okay. And this is really to tell them that the evaluation report has been completed. Gallagher has come out as the top ranked proponent, and that this is our recommendation, correct?
Correct.
Now, by the 8th of August, the decision has been taken internally to waive the standstill period according to Mr. Pearson. Yes?
Correct.
Now, sorry, I'm not sure. I'm not sure if my friend was saying something. I just heard something.
Apologies. One of the persons in the room with me just coughed.
Okay,
Mr. Price, the accounting officer, is on my right. Miss Dana Marie Smith is on the left.
Okay. Yes, Mr. Narsingh, this document to the Procurement and Disposal Advisory Committee says nothing about a decision to waive the standstill period. Do you agree with me?
I believe so, yeah.
And it also says nothing about there being any, and I want to get what your email says. It says nothing about there being any concerns given the imminent expiration of the current contract for insurance brokerage services. If you'd like to look at it in greater detail, but it doesn't say anything about that, does it?
I believe so.
You believe it does?
That it doesn't state the imminent. It just
Yes.
have the expiration dates 30th of September.
Well, if we look at paragraph 2.3 of that document, it says there with respect to the expiration of the brokerage service contracts, it says Gallagher, formerly Risk Management Services Limited, has been providing insurance brokerage services for general insurance since October 2017. The current insurance brokerage service contract with Gallagher for the general insurance portfolio is due to expire on 7th August. That's the day before you sign this document. That contract comes to an end, correct?
Correct.
Yeah, so, and it doesn't say anything in here about any kind of urgency. There's no recommendation to do anything but ask the Director General of Civil Aviation to approve what the evaluation report has said. It doesn't say this recommendation is to be dealt with urgently.
Correct.
And if we go, please, to the document before that, the memo, to the document before page 52. And this is a memo to the Director General of Civil Aviation from Procurement Officer. That's you?
Correct.
And this document says that the Procurement and Disposal Advisory Committee reviewed the evaluation report for the award of contract for provision of insurance brokerage services, namely general and group health and life. And then you have the recommendations there to approve the award of contract to Gallagher for the provision of insurance brokerage services for general insurance. And then the second bullet point is for group health and life insurance for the period October 1st. And again, Mr. Narsingh, this is dated the 8th of August, 3 days after the respondent says that this decision was taken to waive the standstill period. And there is nothing in this document that says we recommend that this is done urgently.
Nothing written.
No. And there is nothing in here that talks about the standstill period being waived for the award of the contract. And are you aware of any documents disclosed in these proceedings, any internal communication at all that mentions anything about the decision to waive the standstill period, Mr. Narsingh?
I don't think I understand the question.
You know, when you filed, you were the person who prepared the Form 9 reply?
Yes.
Yes, and part of that Form 9 included a section with documents, disclosure of documents. And in fact, the respondent did disclose some documents. Do you recall that?
You'll have to see the documents to verify.
Okay. Well, I mean, I don't know that I necessarily needed to see the document, only to answer the question whether you are aware of any documents disclosed. Are you aware of any documents disclosed at all, Mr. Narsingh, by the respondent?
I can't recall offhand.
You can't recall offhand. Will you take it from me that there are no documents disclosed which record any communication, any internal communication within the respondent about the decision to waive the standstill period?
Is that a question?
I asked if you would take it from me.
I'm not sure if I would rely on your observation.
Okay, but you have not disclosed anything, have you?
Not to my recollection.
Okay. Now, you say please bear with me one moment, Mr. Narsingh. I'm just trying to get to the part of the witness statement I'm referring to.
Sure.
Are you being familiar, Mr. Narsingh, with Section 35 as you are? You would be familiar with Section 35(5)?
Not the top of my mind.
I don't know if this is something that we can pull up for the witness. But Section 35, subsection 5, states that the decision of a procuring entity that urgent public interest considerations exist and the reasons for the decision shall be included in the record of procurement proceedings. You're not familiar with that part?
It sounded familiar.
It sounded familiar. But as far as you are aware, the reasons for the decision have not been included in the record of procurement proceedings.
Could you specify if there's a particular format for that?
I'm simply asking whether you agree that the decision has not been included in the record of procurement proceedings. If you don't agree with me, then you can say so.
I don't agree.
Okay. Now, if we look at that part of your witness statement, which talks about you evaluating the bids, I beg your pardon. You have said in your witness statement, Mr. Narsingh, that you received the evaluation report on 2nd August. At paragraph 13, you undertook a thorough review to ensure compliance with the criteria outlined in the RFP, and you were satisfied that the evaluation process was conducted in a fair, objective, and transparent manner. Yes?
Yes.
And you understood that the evaluation ought to have been conducted applying the criteria that was set out in the RFP?
Correct.
Thank you. Mr. Narsingh, finally, are you familiar with any section of the Act or the regulations that exempts special categories of industries from the provisions of the Act?
Not to my knowledge, no.
And save and except for Section 35(4), which you're familiar with, are you aware of any section of the Act or the regulation that refers to public interest considerations?
Not the top of my head.
Thank you. I have no further questions for this witness.
Mr. Chair, just one area of redirect.
Yes, ma'am.
In response to my learned friend, she indicated that you became aware that a decision was taken by the organization to waive the standstill period on August 5th. Yes?
Yes.
And some 13 days later, the decision was taken around August 16 to notify the interested party of the award.
Correct.
And you were asked, well, do you not agree that there was enough time there and before the letter of, and you also indicated in response to my learned friend that you issued a letter of award on August 29th. Yes?
Correct.
And it was suggested to you, well, would you not agree that in that period there was enough time for TTCA to hold the standstill period? And you said, no, you do not agree.
Correct.
Why?
Because of the processes involved in the different categories of insurance, meaning particularly the general insurance. But the subject matter expert will speak more about that.
Right, so it was in relation to the urgency related to the insurance coverage, not to the brokerage services contract. Is that correct?
Correct.
Nothing further, please.
Ms. Sina, do you have any questions of the witness?
No questions for this witness, please, Mr. Chair.
Thank you, Ms. Sina. This witness is now relieved.
Can you get,
Thank you.
can you ask Ms. Nirvana Gabriel? Mr. Chair, we call Ms. Nirvana Gabriel.
Mr. Chair, might I just ask your leave for Mr. Byrne, who is with me, to be relieved for 5 minutes? He just needs to step out of the room. We just want to make sure that we're complying with the rules.
Noted, Mr. Patrick. Mr. Byrne?
Thank you.
Yes, Mr. Chair.
Leave granted for you to remove yourself from the room for 5 minutes.
Thank you.
Mr. Chair, Ms. Nirvana Gabriel is in the room.
Thank you, Ms. Rose.
Good afternoon, Ms. Gabriel.
Hi, good afternoon.
Could you please repeat after me?
Sure.
I, please state your name,
Nirvana Gabriel,
do solemnly, sincerely, and truly affirm
do solemnly, solely, and sincerely affirm
that the evidence I shall give to the hearing panel
that the evidence I shall give to the hearing panel
in this case shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth. The witness is tendered for cross-examination.
Patrick?
Thank you. Good morning, Ms. Gabriel. You'll let me know if you're not hearing me at all, because I know there are some technical difficulties on that end. Ms. Gabriel, you manage the general insurances portfolio, correct?
That is correct.
So you keep informed of when those contracts, whether it's policy or the brokerage services contracts, are due for renewal. Yeah,
that is correct. Yes.
And we were told that, or it was confirmed by Mr. Narsingh, that the existing brokerage contract for general insurances came to an end on the 7th of August 2024.
That is correct.
Yes. And that contract was in place for how long? What was the term of that?
It was a three-year period.
Okay. So, but the 3 years, you're aware that this date is coming up on the 7th of August, yes?
That is correct.
Knowing that, and I assume anticipating the end of the brokerage services, Civil Aviation commenced this procurement process. And within that process, there are certain timelines set out. Yes. Or at least are the timelines determined internally? Yes. Okay. And is it fair to say, Ms. Gabriel, that civil aviation, having managed the insurance portfolio for, I think it's been said, over 2 decades, has ample knowledge about the time required for policy renewals? Yes, that is correct. And you have given evidence, or you and another witness have given evidence about the time that it takes to renew the policy contracts. And there's also been evidence about the time that it takes to transition. So those are things that are within the respondent's knowledge. Correct. The contractors under this procurement process submitted their proposals by the 5th of July, which was the extended deadline. Correct? Yes, they did. Correct. And almost an entire month later, Ms. Gabriel, the evaluation report is complete when we know that Gallagher was the first top rank proponent. Yeah? Correct. Yes. Mm-hmm. It's not your evidence that any concern was raised between July and August that the timeline was too short. Right. Between July and August. Yes. Mm-hmm. And it is not your evidence that there was any discussion about expediting this evaluation process between July and August. No, that was not written in my witness statement. Right. Yeah. And we know that from the evidence of Mr. Pearson that the concerns were raised on or around the 5th of August. Right. That was a conversation. That was an internal conversation that was had with the executive and the procurement officer. Right. And what Mr. Pearson says, I'd like to just get it. Mm-hmm. Is that on or about the 5th of August, I was presented with concerns by Manager Corporate Planning Department, that's you. Correct. Mm-hmm. About the timelines for completion of the procurement process to enable the on-time renewal of the insurance policies. The concerns address a short timeline for the award with the risk of late appointment of a broker with the implication of a lack of coverage, exposure to third-party damage and injury, which raise serious public interest concerns. So these are the concerns that you raised on the 5th of August, and we know that that is 2 days before the general insurance services contract is coming to an end, correct? Right. That would have been the SLA with Gallagher and not the end of the insurance policies, right? Yes. Okay. So right. All I was asking is that was the discussion that was had 2 days before. Right. I just wanted to confirm that. Yeah. Mm-hmm. Yeah. So I'd like to look at paragraph 11, Ms. Gabriel, of your witness statement. Oh. Yes? Okay, it's up on the screen. Yeah. So I think it will be helpful to read it out. Given the time-sensitive nature of the situation, the standstill period was waived, taking into consideration the specific considerations in securing international insurance placements for the aviation liability insurance. And just to confirm, those specific considerations, well, you haven't actually said what those are. So let me finish reading the paragraph and then we'll get to the conclusions. Due to the years of experience managing the insurance portfolio, Civil Aviation is aware that in order to obtain insurance coverage for the next renewal period, the process commences at least 8 weeks prior to 30th September of the current year. This left limited time for delays, which could have jeopardized the continuity of coverage. By waiving the standstill period, the organization ensured that insurance protection was maintained without risking gaps in coverage, which could lead to significant financial and operational vulnerabilities. And then you put a table there showing renewal meetings and the dates that the aviation liabilities have been obtained. Now, did this in your, what is that, second to last sentence? This left limited time for delays which could have jeopardized continuity. The this that you are referring to there, Ms. Gabriel, that is the internal timelines, isn't it?
That would be correct. Yes.
Okay. And those are internal timelines set by civil aviation, correct?
Well, we have to go back to what would have caused that, really.
Well, hold on. Sorry, Ms. Gabriel. If there is a need for you to elaborate on any answer given to my question, if there's any ambiguity, the representative for the respondent will ask those questions. But for these purposes, the question that you are answering is my question.
No problem.
So the
answer to that question, it would be yes, that's correct.
Yeah. And the answer that you were attempting to give is, just to be clear, not something that's set out in your witness statement, is it?
No, it was not set out in my witness statement.
Okay, right. And I'm saying to you that the internal timelines not being sufficient to ensure the on-time renewal of the policy contracts is entirely the civil aviation's own fault. Do you agree with that?
No, I don't agree with that statement.
You've not said that it was the fault of any supplier or contractor tenderer to these proceedings in your witness statement.
No, because my witness statement did not require that I state that.
Okay, that's all right. I'm just asking, and you've not, in fact, given any reason beyond it's essentially what you say here, that you had limited time for delays. You haven't given any reason.
No.
And I am saying to you that the reason is purely that civil aviation, knowing full well what the process would require, did not give itself sufficient time to complete this procurement process. You agree with that?
No, I don't.
And I am saying to you that the situation was entirely avoidable had civil aviation set proper timelines.
No, I don't agree with that.
Okay. Now, at the meeting on the 5th of August, Mr. Pearson says that you discussed a plan to expedite the remaining internal processes. So he says when you realize that the timeline does not allow for the on-time completion, you have this urgent meeting and you discuss a plan to expedite the remaining internal process. Do you recall that?
Yes, I recall that conversation.
And Mr. Pearson said the projected timeline from this plan of expediting the remaining stages, however, still did not allow sufficient time to facilitate the on-time renewal of the policies. Are you at liberty to tell us what that plan was?
Okay, based on my recollection, that conversation that was had was, and I'm just going back in terms of my timeline, if that's okay.
Yes.
Yeah. We would have realized that around the intention of the evaluation process was for us to close off on the 19th of July, right? That was a conversation that we would have had after the proponents would have submitted and it was closed off.
Sorry.
The intention was the 19th of July. The 4th of August, if you could just repeat for me what was captured in Mr. Pearson's statement so I could bring some more clarity.
So yes, let me just tell you what Mr. Pearson's statement says, and then I'll repeat my question because I don't know if it was clear. Mr. Pearson says, the meeting therefore considered a plan to expedite the remaining internal processes by ensuring that they receive top priority at every remaining stage. The projected timeline from this plan of expediting the remaining stages, however, still did not allow sufficient time to facilitate the on-time renewal of policies. So my question really relates to this plan that you discussed in that meeting, not to anything that happened before. He's saying that you discussed a plan when you realize that the timelines are short and you realize, okay, even this plan will not allow us to maintain the OPR processes is what I understand for it. So I just want to understand from you whether you recall discussing that plan.
Right. Yes, we had a meeting on that same set date. And the discussions were around the fact that the 8-week requirement specifically for the aviation liability insurance placements, right? And it was at that meeting that Mr. Pearson was discussing the waiving of the standstill period.
Yes, and you discussed, he's saying you discussed a plan which would have, I understand it to mean, helped you avoid having to waive the standstill period. It would have expedited what was going on.
Well, that question you have to pose to Mr. Pearson for clarity.
Okay, so you don't recall that, or you can't.
The plan part of it, as far as I recall, is for us looking at specifically the aviation liability insurances and saying that based on the history of the contact that we would have had with the insurance broker, that there's a safe 8-week period that we had in terms of ensuring that we had the placement. Right. With respect to the plan that Mr. Pearson is referring to, you'll have to query that with Mr. Pearson.
Okay, and that information that you just gave to us about the considerations that that you discussed about there being needing 8 weeks and so on, that was all information that was known to you at the time that the RFP was issued, correct?
That is correct.
Thank you. So, and just to be clear, you do not specifically recall a plan being discussed to expedite the remaining internal processes?
No.
Okay. Mr. Pearson goes on to say that the meeting critically examined whether the waiver of the standstill period was necessary to allow for an expedited award in order to facilitate a smoother transition, minimizing the risk of coverage gaps and other inherent administrative complications. So, well, was this a long meeting, Ms. Gabriel?
No, it was approximately about 30 minutes.
30 minutes? Okay, well, because this, from what I understand, this is a very, it is a serious meeting at which there are grave concerns about prevailing public interest considerations. And at this meeting, not only are you discussing, well, how do we get through this on time, but you're also taking a decision to waive a period, a statutorily required period, but also something that is set out to the tenderers in the RFP. So I'm surprised. You sure it was only 30 minutes?
Based on my recall, you could further validate that with Mr. Pearson.
Okay. And anybody took minutes of this meeting, Ms. Gabriel?
No. We took our own notes.
You took your own notes.
And
are you aware that none of those notes have been disclosed in these proceedings?
Excuse me?
Are you aware that none of those notes have been disclosed in these proceedings?
Now I'm aware.
Are you aware? There's absolutely no contemporaneous evidence, documentary evidence, recording this meeting at all, or the decision taken at this meeting, Ms. Gabriel.
Okay.
Now, we know, Ms. Gabriel, that on the 16th of August, so that's 5 days after the meeting. Sorry, I beg your pardon, that's 10 days after your meeting. the contract was awarded?
There was a verbal conversation with Gallagher, right? That they were successful in the as a result of the evaluation process. Yes.
Well, I appreciate that, Ms. Gabriel, but that's not what I just said. I said we know that the contract was awarded 10 days later. Yes?
Okay, we go with that. Yes.
And what the respondent has posted on its website in the form of notice to the public. Maybe I should pull that up for you. Let's just find this now. Or will you accept then that the notice to the public on the website says that the date of the award of the contract is the 16th of August?
Yes, I'll accept that.
And you know also that the letter of appointment is issued on the 29th of August.
Yes, that is correct.
And it is by that letter, Ms. Gabriel, that the interested party is authorized to commence with negotiating contracts and so on.
Can you just repeat that for me?
It is the letter of the 29th of August which authorizes Gallagher to commence work.
Okay.
Will you agree with me, Ms. Gabriel, that from the date of the decision, that is the 5th, and when I say the decision, I mean the decision to waive the standstill period, nothing really seemed urgent based on the conduct of the respondent?
I don't agree with that.
And in fact, the concern that Mr. Or is it your concern? Let me be clear. The concern that a broker would be appointed late. The broker was appointed late anyway, were they?
Okay, we went through the process and based on how the process would have rolled out, that was the timeline, and the broker letter was provided on the 29th.
Right, but so the
So
broker
whether
was
it's late, I mean, at the end of the day, we executed what was required.
But the appointment of the broker was late. Having
Okay.
regard to when the general insurance's coverage contract came to an end, the appointment of the broker was late.
Okay.
In the interim, Ms. Gabriel, the general insurance policy contracts, meaning in the interim, once the brokerage contract came to an end, the general insurance policy contracts that were in existence continued.
That is correct.
And I am suggesting to you that based on the timeline that we have just gone through, there was enough time for the standstill period to be adhered to. You agree with that or you don't?
I don't agree with that.
Okay. Now, you signed the note to I'm calling them the PDAC, just for,
Right.
yes, on the 8th of August, which is the page 54 of tab 9 to 20, please. Ms. Gabriel, I'm going to pull it up for you.
Sure.
Thank you. Yeah, so you're familiar with this document, Ms. Gabriel?
Yes.
Can you just clarify? So the document is submitted by Mr. Narsingh. It's dated the 8th of August, and it says recommended by you.
As one of the parties, that is correct.
Okay, and that is recommended by you, having considered the evaluation report.
That is correct.
Okay, and if we go to clause or paragraph 2.3 of that document, yes, you see, we're setting out there for the committee that the Insurance Brokerage Services for General Insurance due to expire on the 7th of August, and this document is actually issued on the 8th of August. So when I said to you that there was a late appointment of the broker, I meant that some time passes between the 8th of August and the 29th of August.
Noted.
And there's nothing in this document, this recommendation to the committee, which says we have these grave concerns about risks to the public at all.
No, it was not captured in the PDAC note.
No, there's nothing in there about urgency at all, urgency to appoint the broker. There's nothing in
No,
there.
I answered already. I said there was no urgency in the PDAC note.
Right, and there is nothing in there saying having regard to when the policy contracts will be renewed. There's nothing mentioning when the policy contracts need to be renewed or time at all.
Well, that is always in alignment with our fiscal year end.
Okay.
To do September. So there's no need to actually capture that in the notes additionally.
And there's nothing about the decision to waive the standstill period.
No,
okay.
Not in my recollection in the notes, in the PDAC note.
Thank you. Now, in your witness statement, Ms. Gabriel, with reference to the respondent's view that the extension of the existing aviation liability insurance was not favorable due to the evolving nature, you say due to the evolving nature of risks in the aviation industry, which may not be adequately addressed by an outdated policy. Yeah?
Outdated insurance policy, that is correct.
Yes, correct, yeah. Now, am I correct in interpreting that to mean that there will be risks that arise that you cannot anticipate? I'm just trying to understand what you're saying there.
Right, to the insurance. Can I just have a look at the
Sure, yes.
Yeah, that's okay. Yeah.
Yes. Can we take Ms. Gabriel to her witness statement at paragraph 12?
Mm-hmm.
So it starts on page 5 and then we move on to page 6.
Mm-hmm. What exactly is the line you're referencing?
So I'm referencing the beginning of page 6 where you talk, or the end of page 5 into page 6, where you talk about the evolving nature of the risk of the aviation industry. And I understand you saying that that's why the respondent did not consider it to be a good option to extend its existing insurance policies. But I want to understand what you mean by the evolving nature of risk in the aviation industry.
Right. That was premised based on the international insurance coverage, right? In terms of what they would assess us, in terms of the question that they will ask us, were there any near misses, air proxies, that type of thing, right? That they needed that information on one, as well as the evolving risk in the insurance industry. It speaks to what's happening outside there in terms of the environmental impacts, those type of things impact the aviation industry and would inevitably impact the insurance coverages on the international market.
So I'm trying to understand why you say that those risks would not be adequately addressed by any existing policy.
Let me just read my statement so that
Yes.
I'm sure, right, that that's okay, right? The
Yes.
TTCA did not view the extension of the existing aviation liability insurance as favorable due to the evolving nature of risk in the aviation industry, which may not be adequately addressed by an outdated policy.
Yeah.
Right.
So
So
that's
that meaning that should we extend or for an option to extend was not considered favorable for the Civil Aviation Authority. Basically, from the perspective that we needed to advise with respect to the nature of risk within our industry, what we specifically operate, right? Were there any near misses? Were there any the amount of the aircraft that traverse the PIACO FIR, the air traffic controllers? All of those things vary from year to year, right? And those are the things that needed to be disclosed to the International Insurance Agency so that they would be able to assess the risk of the TTCA to determine whether we would be allowed or they would have an appetite for our aviation liability insurance.
okay, but what you just talked about there is not evolving nature of risk. That's talking about, you're saying now this is what we have experienced under our previous policy. This is the information that we are providing in order to gain a new policy. But when you talk about evolving nature of risk being a reason to not opt for renewing policies, my understanding of that is you saying that there will be risks that arise that you can't have anticipated. Am I wrong to say that?
There will be both. There will be both. There would be internal risk, right? Because once you start having additional air traffic controllers, right, or different levels and so forth that you need to disclose to the insurance agency, that's risk internal to the authority, right? For which those persons, the international agency, will have to do their assessment to determine whether they have the appetite for our portfolio, right? So that's internal risk. External risk treats with what's happening in the aviation sector, right? Which would be a combination of the international insurance assessment to determine, okay, we have the appetite for Trinidad and Tobago Civil Aviation Authority based on the risk that the internal risk that they would have disclosed based on what is happening in the international sector and the aviation sector on a whole, right? So the evolving risk can be, and it is, both internal and external risk.
Okay, but that risk exists whether the procurement is completed or not. You're never going to be guaranteed, even under your new policy, even under a future policy, to be covered for every possible risk, because as you say, the nature of the industry is such that it's evolving.
Correct.
Okay. So I'm saying to you that that's not a good reason for the respondent choosing not to mitigate its risk by extending the policies. You agree with that?
No, I don't, but I hear your point.
And currently, there is a month-to-month, or there's month-to-month coverage for the current broker for group health and life. There's an extended policy. I know that health and life is not your portfolio, but you are aware that there's month-to-month coverage with that broker.
Correct.
Yeah. And there also has been disclosed in these proceedings insurance policies for the period October 2024 to I believe it's September 2025, which were obtained with respect to general insurances.
That is correct.
Okay. I have no further questions for this witness, please.
Okay. Ms. Rose?
Yes, Mr. Chair. You indicated to my learned friend that you did not agree that there was enough time for the standstill period to be adhered to, even though you all had given a late appointment letter. Can you explain why you say you do not agree that there was enough time for the standstill period to be adhered to?
Particularly because of the timelines, the internal timelines of the processes that we would have gone through. And the intention was for the process, the entire process, to conclude by the 19th of July, right? And with the evaluation would have taken some additional time due to the addition of the group health and life insurance portfolio. That in the past, that was not something that we would have had joint with the general insurances. So those two portfolios came together, and it was an additional information for the evaluation team to process. Right. So once when we had a meeting on the early part of July, the intention was for the award and everything to conclude by the 19th of July.
And if it had concluded by the 19th of July, there would have been enough time for a standstill period then.
That is correct.
It was always also suggested to you that the TTCAA, that is your organization, did not give itself enough time to complete this process. You did not agree. Why is that?
Because I felt that at the start of the process, when we looked at the 22nd of May, it was advertised, and then we would have given the time frame for July, a 1 month period. There was further requests from the proponents that would have allowed for additional time that would have extended the process as we went along. But in the interest of ensuring that we provided transparency in the process, the information that was requested was submitted via addendum to the proponents.
And can you make clearer the distinction between the expiration of the insurance brokerage contract on August 7th and the expiration of the general insurance's policies in respect of this standstill period issue that it has been put to you that you had enough time to do a standstill period?
Right. So the insurance brokerage services would have ended on the 7th of August, the SLA, and the insurance policies were still in effect to the end of the fiscal on the 30th of September. Two different issues, right? So fundamentally, when we looked at it, we were looking at and which we always do, it is the end of the fiscal period, because the concern is that we do not have adequate insurance by the 1st of October, right? So the SLA with the insurance brokers was 7th of August, and the insurance policies expiration is the 30th of September.
And in your witness statement, you indicated the length of time at paragraph 11 that my learned friend cross-examined you on, the length of time that it takes to address the general insurance's coverage.
Correct.
And that was?
It specifically for the aviation liability is an 8-week period.
And so on August 5th, when you all were looking at the evaluation process and the report and bringing this to an end, was that discussed? August 5th, September 30th, was that discussed at this August 5th meeting?
That the end of 30th of September in terms of the expiration of the insurance contract. So yes, that is correct.
I have nothing further, please.
Ms. Sina, do you have any questions for the witness?
No, please.
Thank you. Ms. Rose, your witness is relieved.
Let Ms. Sunita Farabina.
Before, Ms. Rose?
Yes, please.
Before we proceed with the next witness, the panel would like to take a short 5-minute break and we would resume shortly thereafter.
Thank you.
Thank you.
Participants?
Mr. Chair.
Given the timeline, and we just have 2 witnesses to present after we close, we are recommending with the agreement of the participants that we take a lunch break and we resume in 1 hour.
Mr. Chair, I have no difficulty with that. I'd be happy for the break.
Ms. Rose?
Much obliged. Yes, please. Much obliged.
Ms. Sinat? Ms. Sinat probably left the room. I would ask Ms. Bermudez if you can advise Ms. Sinat so that the break would be 1 hour rather than the 5 minutes initially suggested. And also, it is now 12:40 on the device I'm viewing, so we would resume at 1:40.
Thank you.
Thank you.
Yeah, we take a lunch. So 1 o'clock.